trigger warning on this. This is a child. This is an 18-month-old baby that was found deceased.
Right now at 6, a heartbreaking end to the search for an 18-month-old little boy. One day after his disappearance triggered an Amber Alert, remains police believe belonged to the toddler were found in a local landfill. Thank you for joining us. I'm Gilma Avalos. Doug Dunbar is off tonight. 27-year-old Cedric Jackson is in police custody. He is the boyfriend of an aunt who was caring for the toddler. Police say Johnson confessed to taking the boy from the Northeast Dallas apartment and putting him in a dumpster. Detectives later found the child's remains in a landfill in Rowlett. We have team coverage tonight, starting with Jason Allen with new details from the arrest affidavit. Jason?
And Dallas police and firefighters and FBI investigators, this is where they made that discovery this morning. They've told us that the boy's body has now been taken to the coroner's office. However, they still maintain a presence out here this evening. Up there on that highest ridge you can see back behind me. That's where they were searching and made that discovery today. Investigators ended up here after finding out that Cedric Jackson, the boyfriend of the aunt the child was staying with, was at her apartment the night the boy disappeared. An arrest affidavit says originally police didn't know that, but it says the aunt changed her story, and other children who were there in the apartment, they confirmed it. The affidavit goes on to say CJ, the baby, had gotten up in the night recently and made a mess of some ketchup packets in the apartment. And because of that, the affidavit says, Cedric Jackson, quote, tightly swaddles CJ at night to restrict the child's movement. Well, early Wednesday morning, it says the boy was wrapped but was making noise. And the affidavit says when subject unwrapped CJ, he began throwing up and became unresponsive. The document says Johnson said he performed CPR, but the boy wasn't moving. So that's when he put him in the car and drove to a dumpster and left him. And other children in the apartment told investigators that they heard the boy, quote, crying in the early morning, late night, then stopped suddenly and then disappeared.
Detectives then learned that the dumpster had been emptied at least twice at a landfill in Rowlett.
We're going to switch gears here to the actual conference that they did have for Cedric Jackson. Bear with me.
Good afternoon. My name is Major Vincent Weddington. My last name is spelled W-E-D-D-I-N-G-T-O-N. First name Vincent, V-I-N-C-E-N-T. Major, Dallas Police Department, Crimes Against Persons Division. We regret to inform you that the Dallas Police Department has located the remains of a small child who we believe to be 18-month-old Cedric Jackson, pending a positive identification. This is not the outcome we had hoped for, and we want to extend our deepest sympathy.
I believe I did the same thing and said Johnson. So just for clarity, the child's name was Cedric Jackson.
Peace to the family at this time. Our officers discovered the child's remains shortly after 11 a.m. today in a landfill in Rowlett. The remains have been taken to the coroner's office to determine the cause of death. We have arrested Cedric Jackson, a black male, 27 years of age, for injury to a child, serious bodily injury, felony 1. Other charges are pending based on the outcome of the coroner's report. Our detectives learned that Mr. Johnson is the boyfriend of the aunt who had temporary custody of Cedric. After questioning the family on Wednesday, our officers discovered that Mr. Johnson was at the apartment when the abduction took place. We questioned Mr. Johnson, who then confessed that he had taken Cedric from the apartment and placed him in a dumpster in Northeast Dallas. When the detectives arrived at the dumpster, they discovered that Cedric's body was not there. Detectives then learned that the dumpster had been emptied at least twice at a landfill in Rowlett. Dallas police, along with local firefighters and agents from the FBI, went to the location to search the landfill. Cedric remains again were found shortly after 11 a.m. today.
Just for anybody who might be coming in late, this is from 5 years ago. This is the Dallas Police Department. They held a news conference regarding the abduction and the remains of 18-month-old Cedric Jackson that they found in the landfill.
Currently, we do not have a motive for this crime. It has not been established yet as to when or how Cedric has died. There are still a lot of questions surrounding this ongoing investigation, and we will be able to provide updates as they become available. We want to thank the Dallas Police Department, the Colleyville Police Department, the FBI, the Dallas Fire and Rescue, and the National Information Center for Missing and Exploited Children for their help with this investigation. I'll take questions now.
Well,
Clarifying question.
clarifying.
Anyone have any clarifying questions?
Injured to a child, serious bodily injury, felony 1.
What is Johnson said about what happened?
I can't go into that right now. That it's still an open investigation.
One more clarifying question.
When did you say the confession was? Was it today or was it yesterday?
I didn't say when the confession was. He did confess. I'm not going to get into the timeline on the confession. He did state that he did remove the body from the house.
Thank you, Major. Did a dog find the police?
Major, say the name and title again. Say the title, name and title.
My last name is Weddington, Weddington. First name Vincent. Title is Major, Dallas Police Department, Crimes Against Persons Division.
Major, do you know how long Cedric has been living in that apartment?
No, sir.
Major, is Harold Johnson still a person of interest at all? Is he not connected in this case?
As it stands right now, let me get some clarification on that. He is not considered a person of interest in this case right now.
What about Crystal Jackson?
That's all I have to say.
Thank you very much, Major.
Major, what role did CPS?
Okay, so that's where we were on that. I did a little bit of research on the case and tried to find out as much information as I could. I did find out, let's see here, let me go and share my screen. Make sure I have the right one. I did research on the court, Texas Judicial Branch of the 5th Court. It's actually in the 5th Court under the name Cedric Jackson, the state of Texas versus Cedric Jackson, and the case numbers that are here that are available. There was an initial case type and then an appeal from a pretrial order. And from this page, I was not able to derive any more information. So I went ahead and looked at some details from a different area. Let me pull that up for you. Here we are. I went ahead and pulled up the Dallas County, Texas courts portal. And this shows the case number, the filing date that was in accordance to what the news had reported. And then they've moved it from Criminal District Court 5 to 6 now, and it is still an open case against Cedric Deshaun Johnson. And it does show he has a couple of active attorneys, and although it must have switched attorneys at some point. It looks like maybe several times. It looks like they're all court-appointed attorneys, so whoever he got, basically. Long and short of it. All right, so let's go into some of the actual first-degree felony. He was charged 7/10 of 2019, injury to a child, first-degree felony, bond settings. He did not bond out. The docket sheets here, and what I would like to go over is going to be the initial indictment on 9/23 of 2019. So let me get that pulled up. Okay. I'm just going to read this a little bit and then I'm going to switch over to the petition for discretionary review. Injury to a child in the name and by the authority of the state of Texas. The grand jury of Dallas County, state of Texas, organized on July of 2019, that Cedric Johnson, hereinafter called defendant, on or about the 10th day of July 2019, in the county of Dallas, state of Texas, did unlawfully, then and there, intentionally and knowingly, by omission, cause serious bodily injury to Cedric Jackson, a child 14 years of age or younger, hereinafter called complainant, by failing to seek medical attention and at the time of the said omission. The defendant had a legal and statutory duty to act in behalf of complainant, in that the defendant had assumed care, custody, and control of the complainant. And that was the signed by the foreman of the grand jury. Okay. The next thing I want to do, roll this over here to a different page. Let me share my Let me share with you here. Sorry, give me just a second. This is a 12-page read that we're going to do right now. Bear with me, please. Okay, there we go. In the Court of Criminal Appeals of Texas, the state of Texas versus Cedric Jackson, the appealee. After his arrest and outstanding warrants, but hours before custodial interrogation or Miranda warnings, appellee told the police, "I need to talk to a lawyer." The police later gave him Miranda warnings, obtained a waiver of rights, and questioned him about the current defense. The question before us today is whether the request for counsel before Miranda warnings invoked Miranda protections so as to bar police-initiated interrogation after Miranda warnings were later given. In line with precedent from the United States Supreme Court, we answer the question, no. The right to counsel under Miranda cannot be invoked anticipatorily. The police were allowed to seek to question appellee after giving him Miranda warnings for the first time. Here's the background and the investigation. Trigger warning. This is an 18-month-old child that was found deceased in a landfill the day after they put out an Amber Alert here in Dallas, Texas. An 18-month-old boy, Junior, lived with, his name is, I'm going to just call him Johnson. Let's just call him Johnson. Or actually, let's call him, well, I got a lot of names we could call him, but what is let's say his proper name was, Cedric. So the baby's name was Cedric Jackson, and his name is Cedric with an S. So I'll just call him Johnson, so we're not confusing the two. Cedric Jackson is the baby, and Cedric Johnson is the aunt's boyfriend. I'm sorry. Okay, let's go back to it. An 18-month-old boy, Junior, lived with Johnson and his girlfriend, who was the child's guardian. Junior was reported missing early one morning. Multiple divisions within the Dallas Police Department, involving hundreds of people, began to search for him. Johnson went to the police station to help. Detective Angela Hernandez was assigned to gather background information about people close to Junior, and Johnson was one of those people. He was taken to an interview room, and at 2:30 p.m., he was interviewed by Detective Carrington, starting at 5:57. may a reviewing court rely exclusively on the custodial interrogation environment rather than assess whether a defendant was subjected to interrogation regarding the invocation of the right to interrogation counsel? And, if so, may a defendant prospectively invoke their right to interrogation counsel before being subjected to questioning? We already got the answer from that of that. Starting at 5:57, Detective Hernandez. Oh, let's go to the next page for you. There we go. Detective Hernandez conducted a second interview with Johnson. After the interview, Detective Hernandez left the room to talk to other detectives and was gone for some time. At 7:18 p.m., Johnson left the room to inquire about his children. At around 7:35 p.m., Johnson returned to the hallway outside the interview room. He asked where his children were, and Sergeant Herrera responded that they were being questioned at the Dallas Advocacy Center regarding a criminal offense. Johnson asked what the offense was, and the officer responded that it was kidnapping. The officer explained that the children were witnesses to a boy going missing, so police were questioning them. Johnson replied that the children had nothing to do with it. The officer emphasized that the children were there and saw what happened. Johnson then asked, "Who says they were there?" The officer responded, "They did." At about the same time, Johnson was placed in handcuffs. Johnson then said, "Okay, I need to talk to a lawyer." Sergeant Herrera responded, "Okay, but you still need to sit in that room." After talking about the children being at the advocacy center and whether his grandmother was there, Johnson said, "I don't mind talking to nobody as long as I know my kids are all right." Johnson was told that he was being arrested for out-of-county warrants. He asked to call his grandmother, but the officer did not permit him to do so at that time. No lawyer was ever called. Inside the interview room, Johnson asked again about the whereabouts and conditions of his children. Sergeant Herrera informed Johnson that his children were safe at the Dallas Advocacy Center. Johnson remained in the interview room for 6 hours. During that time, he called out to officers for some water and for help in getting up from the floor and loosening his handcuffs. He also asked about his warrants, whether he was going to be transported somewhere, and what was going on with his children and his girlfriend. Officers told him that people were still being interviewed. They might need to interview him again, and they would try to get an update for him. At about 1:20 a.m. the next morning, Detective Rico Harris entered the interview room to speak with Johnson. Detective Harris had not been told what Johnson had said about talking to a lawyer. After introducing himself, Detective Harris provided Johnson with a Miranda warning card and read the warnings required by Miranda and Article 38.22. Johnson signed and dated the card and agreed to talk. He told Detective Harris that he was next to Junior playing a game when Junior started throwing up. Johnson performed CPR on him and then wrapped him in a blanket and started driving around. He was afraid to take Junior to a hospital because of what people would think. Johnson eventually led the police to a dumpster where he had put Junior's body, which was later found in a landfill. Johnson was charged with injury to a child by omission and capital murder of a child under 10 years of age. He moved to suppress his statements to law enforcement and all pictures or diagrams of the victim's body. There was a suppression hearing, and so we're going to talk about that now. At the suppression hearing, Detective Hernandez and Harris testified to their interactions with Johnson. When he asked what she thought Johnson meant by his statement that he needed a lawyer, Detective Hernandez said she took it to mean that he's thinking he needs his children represented. When questioned by defense counsel, Detective Harris testified that he would have asked for clarification if he had known that Johnson had told another officer, "I want to talk to a lawyer." When asked by the trial court if he would have continued to question Johnson if Johnson had told him that, Detective Harris responded, "No. If he had said it to me, I would have stopped the interview." When further asked if he would have stopped the interview if the suspect had said to him, "I need to talk to a lawyer," Detective Harris said he would have. The trial court granted Johnson's motion to suppress. An appeal. The trial court denied the state's motion for reconsideration, and the state timely filed an appeal. The Court of Appeals affirmed the trial court's order suppressing Johnson's statements to the police. The Court of Appeals concluded that Johnson was subjected to custodial interrogation, that he invoked his Fifth Amendment right to counsel, and that police violated his right to counsel by interrogating him after the invocation. The Court of Appeals conceded that the United States Supreme Court has held that Miranda rights cannot be invoked anticipatorily, for example, in a situation other than custodial interrogation. But the Court of Appeals held that Johnson had been subjected to a custodial interrogation environment because he had been interrogated before being placed into custody, and after being placed in custody, he was sent back to the interview room with the plan to interrogate him later. The Court of Appeals has found that Johnson's statement, "I need to talk to a lawyer," was an unambiguous invocation of his Fifth Amendment right to counsel. In arriving at this conclusion, the appellate court relied in part on the notion that the trial court was free to discredit Detective Hernandez's testimony, that she interpreted Johnson's request as one that ultimately sought representation for his children. The Court of Appeals also noted Detective Harris's statement that if he had known about Johnson's statement about needing a lawyer, he would have stopped the interview. Finally, the Court of Appeals rejected the state's argument that Johnson waived any invocation of his right to counsel when he said, "I don't mind talking to nobody as long as I know my kids are all right." The court held that the state never satisfied the condition for talking because it never allowed Johnson to talk to his children to personally ensure that they were safe. The analysis: the Fifth Amendment provides in relevant part that no person shall be compelled in any criminal case to be a witness against himself. In Miranda v. Arizona, the Supreme Court held that to ensure that the right against compelled self-incrimination was honored, certain procedural safeguards had to be met. One of these safeguards was to inform the suspect before custodial interrogation that he had a right to the presence of an attorney, either retained or appointed. This right included the right not only to consult with counsel prior to questioning, but also to have counsel present during any questioning if the defendant so desires. And if, after being informed of this right, the suspect requests counsel, the interrogation must cease until an attorney is present. The Supreme Court has referred to the requirements of Miranda as a prophylactic rule, though one that is based in the Constitution. In Edwards v. Arizona, the Supreme Court went a step further. When a suspect invokes his right to counsel under Miranda, the police must not only cease any current interrogation, but they may not seek to interrogate the suspect again, even after further Miranda warnings, unless the suspect has been given counsel or the suspect himself initiates further communication with the police. The Supreme Court has referred to the Edwards rule as a second layer of prophylaxis on top of the Miranda rule. In Minnick v. Mississippi, the Supreme Court held that once the Miranda-based right to counsel has been invoked, the Edwards prohibition against further police-initiated questioning remains, even after the suspect has consulted counsel, if counsel is not present during the interrogation. The Supreme Court has referred to the Minnick construction of the Edwards rule as a third layer of prophylaxis. They cite a lot of case law, don't they? In McNeil v. Wisconsin, the Supreme Court held that it would not add to these protections by allowing a suspect to anticipatorily invoke Miranda rights. The court said that it had never held that a person can invoke his Miranda rights anticipatorily in a context other than custodial interrogation. In McNeil, the Supreme Court found that a defendant's request for an attorney at a bail hearing did not undermine subsequent Miranda waivers on offenses other than the one that was subject of the bail hearing. After holding the assertion of the Sixth Amendment right to counsel, example, at a bail hearing, does not in fact imply an assertion of the Miranda Fifth Amendment right to counsel, the Supreme Court addressed whether we should declare it to be such as a matter of sound policy. In answering the question no, the court observed, if a suspect does not wish to communicate with the police except through an attorney, he can simply tell them that when they give him the Miranda warnings. The Supreme Court found it significant that the interrogations in McNeil were about offenses other than the one which the bail hearing was held, because the Sixth Amendment right to counsel is offense specific, while the Miranda right to counsel is not. Under Michigan versus Jackson, an attempt to interrogate McNeil on the offense that was the subject of the bail hearing would have been barred under the Sixth Amendment because of his prior invocation of counsel at the bail proceeding. But Michigan versus Jackson was overruled in Montejo versus Louisiana. In overruling Jackson, the Supreme Court said that the three layers of prophylactic protection imposed by Miranda, Edwards, and Minnick were sufficient. In concluding that Jackson's additional protection was unnecessary, the court reiterated the observation in McNeil that a defendant can simply invoke his right to counsel at the time Miranda warnings are given. It's a little wordy, isn't it? It's a lot of case law, citing a lot of case law. In our later opinion in Pacina versus State, we discussed the Supreme Court's statement in McNeil that the Supreme Court has never accepted the notion of an anticipatory invocation of Miranda rights. We held that under Montanejo, the Fifth Amendment right to interrogation counsel is triggered by the Miranda warnings that police must give before beginning any custodial questioning, and echoing both Montejo and McNeil, we said that a defendant who does not want to speak to the police without counsel present need only say as much when he is first approached and given the Miranda warnings. Under McNeil and Montejo, the Miranda right to counsel, with all of this prophylactic protections, becomes ripe for invocation only after 1. Miranda warnings have been given while the suspect is in custody, or 2. If custodial Miranda warnings have not been given when custodial interrogation begins. The Court of Appeals erred by relying on a supposed custodial interrogation environment to establish a violation of Johnson's right to counsel under Miranda. When Johnson voluntarily participated in the first 2 interviews, he was not in custody. Later, when Johnson was placed in custody, he was not given Miranda warnings, and no one attempted to interrogate him. Later still, before interrogating him, Detective Harris gave Johnson Miranda warnings for the first time. It was at that point when the detective read the warnings. Then Johnson had the choice contemplated by Miranda. Having been told for the first time while in custody that he had a right to counsel before and during interrogation, Johnson could have invoked that right. He chose not to, and the Court of Appeals erred to rely upon any supposed police plan to conduct a custodial interrogation later, assuming without deciding that the record would support a conclusion that the police had such a plan. It does not matter. The only time a plan to interrogate matters is when a police officer begins a custodial interrogation without giving Miranda warnings as part of question first, warn later technique that is deliberately designed to circumvent Miranda. That did not happen here. Johnson was given Miranda warnings before any custodial interrogation commenced. As we have explained, once he received the Miranda warnings, he could have then invoked his right to counsel. He did not. The police interrogation that followed complied with Miranda. We reverse the judgments to the court below and remand the case to the trial court for further proceedings consistent with this opinion. So there you go. Instead of letting him get away with so basically what they wanted to do before they ever even got to court, they wanted all of this stuff thrown out because he's saying his rights were violated and they're saying no, they weren't. So there you go. All right, one more little thing here. One more little bitty thing. I'm going to share the screen. This is the man that has been charged with the demise of this baby. The man who confessed to police in July that he left Dallas Toddler in a dumpster faces the charges in connections with his death. The grand jury indicted him in September of that year of 2019 and his 18-month-old nephew of Johnson's girlfriend. Johnson had been in Dallas County since his arrest in July. His bail is set at over $1 million. Cedric's disappearance in July triggered an Amber Alert before authorities found the boy's remains the next day at a landfill, which we've talked about. Johnson, who's the boyfriend of Cedric's aunt, confessed to police that he had put the toddler in a dumpster in northeast Dallas. Cedric had been in his aunt's care at that time, police had said previously. I just don't understand why he just decided to up and take this baby out to a dumpster. Apparently, he used to wrap him up, like swaddle him, because he would. Johnson told the police that Cedric had been there it goes right there, swaddled in a blanket on the floor before he passed, according to an arrest warrant affidavit. He told police Cedric had once made a mess. He's 18 months old. What did you expect? Cedric had once made a mess with ketchup packets, so he began swaddling the 18-month-old tightly to prohibit the movement. Friends and family members hold balloons during a vigil for 18-month-old Cedric Jackson on July the 12th. He told police he unwrapped Cedric from the blanket after he heard him making noise around 12:30 a.m. and the child began vomiting and became unresponsive. Johnson told police he gave Cedric CPR for more than 30 minutes and that the child wasn't moving but still had a heartbeat, according to the affidavit. After that, he drove to a dumpster, put Cedric inside. The capital murder indictment for Johnson said he intentionally caused the toddler's death by an unknown manner and means. Johnson also was indicted on the injury to a child charge in September. Johnson's girlfriend, Crystal Jackson, also faces charges of endangering a child in connection to Cedric's death and disappearance. So this is the aunt right here, and she was in charge of him. In an arrest warrant affidavit, police said Jackson lied to police for 19 hours about the amount of time she knew Cedric was missing. Were it not for the actions omissions by suspect Jackson, law enforcement has every reason to believe the complainant could have been located potentially alive within hours of his removal from the suspect Jackson's residence, police wrote. He put that baby in a dumpster still alive. Jackson had called 911 early the morning of July the 10th, telling a dispatcher that her nephew had been abducted. She said only she, another child, and Cedric were home when a man entered the residence and took Cedric, according to the warrant. Police said Jackson repeatedly changed her story about when Cedric went missing, according to the affidavit. Police said she also sent valuable witnesses away from the location from which Cedric went missing, referring to 5 other children who had been in the house at the time. In forensic interviews, children in the home said they heard Cedric crying in the early morning and then he stopped suddenly and disappeared, police wrote in an affidavit. Cedric's mother could not be reached for comment Monday, and a few days after Johnson's indictment, she wrote on Facebook that the boy's aunt deserved the same charge as Johnson. I don't think she has any right to say anything. She wasn't even taking care of her own child. That's just my opinion. You're telling me this woman lied to y'all for over 19 hours when y'all could have possibly found my baby alive, and the highest charge you can give her is child endangerment, and her boyfriend gets capital murder? Deshandra Thomas wrote. Thomas said she wanted proper and deserving justice for her son. Jackson, the aunt, has not been indicted on the child endangerment charges. That's all I got for you today. Just keep this baby Cedric in your thoughts. There's been no updates and nothing has changed. There was a brief. I saw something. That came back November the 13th. So maybe we'll start seeing some movement in the case sometime this year coming up. That's all we can do. After Thanksgiving and Christmas, stuff in court will start moving around again. So thank you for hanging out with me today. Hopefully this was insightful. Any information that you need or anything that you need from me, just leave a comment below. Maybe like and subscribe if you feel like you want to. At the end of the day, do whatever you want to do and have a great rest of your Sunday.